for the Second Amendment purposes and the purposes of other parts of the Constitution, which is wrong, and I think courts have been correct in pointing it out as wrong. But it's a really troubling argument. I mean, you think of somebody indicted for a felony no longer being a part of the people for all of the rights that trigger when you're a part of the people. It's a really scary thing.
What other rights, like right to jury trial or
right.
defense attorney or whatever?
Right. And this argument, I think rightly, has been pretty much laughed out of court so far, but the government keeps trying to bring it in slightly different ways.
Racist taint in a statute from 1877 and surety bonds from 1791. Little bit of history this week here on Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on Tuesday, September 23rd, 2025, and we are going into the pages of the history books and the archives with a couple cases that are both from the Fourth Circuit. Before we get to that, I am going to tell you about a couple live shows that we have coming up Short Circuit. So you've noticed we've had a number of live shows recently, which is great. We love the request to have us come to wherever you are to do a Short Circuit program. And we have a couple coming up. We have our annual Supreme Court preview, which by the time you see this, it will have been recorded, but it should be coming up in the next episode. And that is our annual preview from the University of North Carolina School of Law. Justin Pearson of IJ will be leading that, and he'll be joined by a special guest. I don't know if this special guest is a secret or not. It's probably out in the open at this point. But just to keep our listeners tantalized, I won't reveal the name as of right now. And then a couple weeks after that, we will have a Short Circuit live from George Mason University, from the Antonin Scalia Law School, where I will be leading a panel with my colleague Bob Belden and a couple professors from that law school. So looking forward to engaging with the students at those schools and having all of you listen to the expertise we get from their faculties. But for now, we're going to talk to a couple experts on all things history and the Federal Courts of Appeals. So in a little while, we'll get to a case about the Second Amendment. Now, some of you may be thinking, you guys have done a lot of Second Amendment history episodes recently. Courts of Appeals keep going over what Bruin and Rahimi, these recent Supreme Court cases, have said. Yeah, I get that, right? It's another felon challenging that his Second Amendment rights are being taken away by not being able to have a firearm because of a crime that he committed a long time ago, or whatever it is. Well, they keep happening. They're probably going to the Supreme Court again, so they're important. But also, the one we have this week is a little bit different and makes you think about the case and the issue in a different way. So Dylan is going to give us a little preview about that. So just whet our appetite, Dylan. What is the twist in this one?
Yeah, so this one's a new take on an old classic. Instead of being a convicted felon, we have an indicted felon. And instead of simply owning a gun, we have an indicted felon traveling across state lines with a gun. So that'll be the wrinkle that we talk about in the second of the Fourth Circuit double feature.
Yeah, so it's kind of like a Johnny Cash song, right? He's indicted, he gets a gun, he goes across state lines. What happens? So stay tuned.
The only thing that differs from a country song is that he went to Maryland.
Yeah. Well, there's some parts of Maryland that are a little bit
true.
More maybe country friendly, but maybe not too many. So we'll get to that in a little bit. But first, Daniel Nelson of IJ, our resident historian, he is going to tell us about North Carolina in the days of Reconstruction. I gotta say, I thought I knew a little bit about Reconstruction history and North Carolina's twist on that, but there's a lot in this case that I wasn't aware of. So what's going on here?
Yeah, I mean, I'll just say too, Reconstruction is wild. The more I've looked into it myself over the years, the crazier it gets. So the case at issue here concerns a North Carolina statute that criminalizes certain felons from voting. So the North Carolina A. Philip Randolph Institute, I think I'm like 95% sure I'm getting that name right. They challenged this no voting law, and they said that this law violated equal protection because of the discriminatory intent and effect that it had on Black North Carolinians. Now, to really understand this equal protection argument, we've got to go all the way back to Reconstruction era when this law was actually passed, this no voting law. So it was passed in 1877. This is the tail end of Reconstruction. So this is, of course, after the Civil War. By this time, all the southern states have been readmitted into the Union after begrudgingly ratifying new state constitutions to kind of get rid of their old state constitutions that had a lot of discriminatory elements in it. And at this time, too, or by this time, the 13th Amendment, which bans slavery, of course, and the 15th Amendment, which bans prohibiting denying the right to vote on the basis of color, both of those have been ratified. Now, the southern states, of course, even after they were readmitted into the Union, even after the Civil War, they were very reluctant to just, leave behind their old ways of racism and discrimination against blacks. And so what they did after ratifying their new state constitutions is they passed a slew of discriminatory statutes. Now, we know a lot of them today as the Black Codes, and these punished and criminalized all sorts of conduct. I mean, we're talking walking outside without a purpose was one. Not having like a job identification card. So if a police officer went up to you and said, do you have a job? And a black individual would say, yes, show me proof. If you didn't have it, you could be criminally punished.
Violating a contract in some cases.
Violating
right?
a contract,
was
yeah.
a crime.
Yeah, so like if you wanted to quit your job before an employer wanted you to, you were criminalized.
Right.
That was criminalized, and you were subject to jail and a fine. So there are all sorts of laws like this. And the no voting law that's at issue in this case was one of those laws. Now, at the time, it doesn't have this anymore, and we'll get to that. But at the time, it imposed strict liability for a felon voting in an election, even if that particular felon thought he was eligible to vote. And I don't say he or she because, of course, at the time, women did not yet have the right to vote. So we're just talking about really black men at this point. And like a lot of the black codes of that era, this did not specify that it would only apply to black individuals. But there was a goal here. The goal was to indirectly go after black voters or potential voters. At the time, because of these black codes that were criminalizing just every single sort of conduct you could imagine, incarceration rates for blacks were much higher in the South than they were for whites. And so the idea here was to say, hey, let's pass this no voting law, impose strict liability on blacks who want to vote, because we'll probably get a lot of people who have been convicted of these various vagrancy laws or trying to leave your employer early laws.
So, Daniel, I have a quick question for you.
Yeah, go for it.
You mentioned that a lot of these laws weren't written specifically singling out black people, but that was kind of the animus behind enacting a lot of these laws. So the law in the book presumably could have applied to any felon who tried to vote. Back in the day, I presume they were only enforcing these laws against black people. Is that the case?
Yeah, so it's sort of two things. So at the time, again, because of the black codes, there was just more black incarceration. So that's number one. And then number two, to your point, even the more like, even the laws that weren't kind of meant to target black individuals were just unevenly enforced. And so really, even just the true facially neutral laws were just, they weren't even-handed in application. So this provided a very convenient workaround of the 13th Amendment, which banned slavery, or to use its words, I think it says involuntary servitude, except in cases of punishment. And that was significant because what states in the South would do is they would incarcerate people, and then, and mostly blacks at the time, unfortunately, because of the black codes. And then they would engage in what was called convict leasing. So they would literally lease out these prisoners to railroads, to mines, to large plantations to effectively reinstitute slavery. And so by doing this workaround, by essentially reinstituting slavery through punishment for crimes, you could get around the 13th Amendment. And of course, this also got around the 15th Amendment because you're not directly prohibiting blacks from voting, you're just indirectly doing it after, of course, having incarcerated blacks through the black codes. And so this was a very sneaky workaround, and this law had been on the books for, ever since 1877. It really hadn't ever been changed until 2023, when the state legislature said, hey, let's at least add a knowledge requirement. So you're only going to be liable under the law if you knowingly vote in violation of, your what's the word?
Disenfranchised?
Thank you. Struggling there.
So I have a question on that. Before you get into the meat of the case, I do have maybe this jumps to the end. So I apologize, but
go for it.
The law, right, on its face, it just says this is a crime.
Yeah.
Now, usually in our legal tradition for criminal statutes, the mens rea, the knowledge component, is usually inferred that if you're committing a crime, that it's not strict liability, that there has to be some purpose that you're doing this thing that is made illegal. Sometimes you can have strict liability, but usually, especially for something like a felony, it's almost unheard of. So what I didn't seem like was answered in the case is, it seems like the North Carolina courts have never really interpreted this law, whether it is strict liability or not. It's just some prosecutors enforce it with strict liability, some don't. So shouldn't the Fourth Circuit have at least asked, well, should we just infer a mens rea requirement on top of this statute, because that's normally how you do things in criminal procedure? It seemed like they just said, yeah, it's strict liability, and we're going to interpret it as strict liability.
Yeah, that's a really interesting question. I hadn't thought about that myself. I mean, I think the text of it was quite clear, and I think given the pretty blatant discriminatory intent of the law, it seemed pretty transparent.
Right, it seems the intent was strict liability.
Yeah, and so I think in that light, it was just sort of like, well, if the intent here is strict liability and the plain text doesn't have a knowledge requirement, that's probably the best way to interpret the statute.
I guess I've just been around so many courts doing similar things in all kinds of cases when you're trying to challenge the constitutionality of a law that I was surprised they didn't hear. But
I thought it was strange
I'm not
too.
saying it was wrong. I'm just saying
Right.
I've seen otherwise.
I agree with you on that, 100%.
Yeah, I thought it was strange that this law really only came up now. I mean, I thought that was weird too, that the Fourth Circuit apparently just hasn't been asked to decide whether or not this law was constitutional as it was written up until now. And then I'm starting to wonder, like, is it because most people who would be indicted for violating this law just struck a plea deal because, the prosecutor's office can point to the law and say, well, it says what it says. Did you or did you not try to vote? And then you could intimidate a lot of people out of trying to even assert their rights to begin with. I don't have anything to back that up, but it's my suspicion, I guess.
Yeah, I don't know. I mean, I don't know the degree to which it was enforced. And the court does emphasize that this law did have sort of a chilling effect, that there was evidence of there being a chilling effect. And so even if there weren't many prosecutions, like outright, it was having a chilling effect on this population who was kind of unclear, especially of the state of the law, because in 2023, in response to this lawsuit, the General Assembly added that knowledge requirement explicitly in the statute. But all the parties agreed that so the amendment was in 2023 and the law took effect 2024. But pre-2024 conduct could still be prosecuted under the old strict liability version of the law. And it's just like, you've got retroactivity issues. I mean, it's just like unclear how the new law, the actual current law, and the past law actually work with each other. They're both simultaneously enforceable. So it's just very confusing for lawyers and judges, much less people who just want to see if they can vote or not. So that's the basis of the equal protection claim, is that this law has this discriminatory history, which both parties agree. In fact, the district court called it an extraordinary concession on the part of the government, that they're just conceding the fact that there's discriminatory intent here, which is rare, if not completely unheard of. And of course, it's often very hard to, in other cases, prove discriminatory intent. So that's kind of the backdrop here. Now, under Supreme Court precedent, under the case called Arlington Heights, if a law like this one is facially neutral, but when applied evenly has a discriminatory effect, as it still did even today, as the no voting law here did, and there was a discriminatory intent, that law can violate equal protection. And so that's ultimately, I mean, this seemed like a pretty straightforward application of Arlington Heights. Now, the government did have an argument in response. Their argument was that the discriminatory intent, the original discriminatory intent of the law in 1877, was not relevant anymore. So they did concede that there was a discriminatory effect. Again, you need effect and intent under Arlington Heights. So they conceded effect. They conceded that the original enactment of the law had a discriminatory intent. But they said, the government said, in 1971, we wrote a new state constitution. And in one of our provisions in the state constitution, we expanded the number of felonies. We expanded the types of felonies that could subject you to penalty under this no voting law. And they sort of tried to say, because of this 1971 amendment, there was like a legally significant event that, I mean, I'm trying to do this argument justice. It's a very weird argument. I mean, I think that's all they had. But this 1971 amendment that expanded the types of felonies that people could be, that could trigger the statute, created, in their words, a legally significant event that sort of somehow broke the line of discriminatory intent, you know, from 1877 to today. And the court's
Doesn't that just make it worse?
It does make it worse, but they were just saying, well, but there's just some sort of, something happened to the law, even if it's worse. It's just something, and it's different than what had happened in 1877. And of course, you know, as you're alluding to, Anthony, the court's like, we're not buying this. The Fourth Circuit's like, you know, there's no meaningful difference to the statute here other than just expanding, you know, making the statute worse. But you haven't done anything to clean the discriminatory taint, to use your phrase. And that was the phrase that they had used.
It's weird because, I mean, I think you're doing a good job of trying to articulate the argument as best as it can be articulated, and it's not surprising to me that it fell flat because that's pretty thin. But I was surprised reading this opinion. It seemed like there's some doctrine where if a legislature reenacts the exact same facially neutral but racially motivated law later, exact same text, just a later legislature, then that actually can somehow cleanse the discriminatory intent of the original law. So that seems weird to me to begin with, but do you have thoughts on that or how that might apply in this situation?
I do. So that was my takeaway, which at first I'm like, well, why wouldn't the legislature just, like, they could just pass the exact same statute with the knowledge requirement? You don't have the discriminatory intent from 1877. There's no problem, right? I think, you know, at worst, maybe a court would be a little skeptical, but probably not. I think it would survive. I think the issue here, though, is you still had, like, prosecutors still had the ability to enforce the old law against pre-2024 conduct. And so if the legislature were to enact a new law that was exactly the same as it is today with the knowledge requirement, it would be different because, yes, it's the exact same text, but you don't have the previous version, the strict liability version that you can still enforce. You know, that law would be repealed and the new law could only be enforced, which would require knowing violation of the no voting law, if that makes sense. So yeah, I think that's the distinction there.
I know that adding the knowledge requirement was obviously important because without that, maybe the Fourth Circuit would eventually construe the statute as imputing one. Mm-hmm. Maybe it wouldn't. I know that has a bunch of knock-on consequences. But even the idea that you can reenact the exact same statute word for word and somehow that removes the discriminatory intent of the original statute seems a little bit weird to me.
Yeah, I mean, I don't deny that. And I think that just goes to the heart of courts, you know, presuming maybe a little bit too much about good faith of legislation, the constitutionality of legislation, which they did not do here. And it was very interesting and maybe a little bit refreshing to see the courts, both courts, the lower court as well, sort of not afford that presumption. Now, granted, the government conceded the discriminatory intent of this law, so it made it made it a little bit easier for the court here. I guess last thing I'll say, at first I was a little confused as to why the government was relying on like this weird 1971 constitutional amendment argument, and not just the fact that they had amended the law to require knowledge. But again, because I think that knowledge requirement would probably provide a clean enough break so that, you don't have the discriminatory intent from the 1877 law. But again, because prosecutors could still enforce the old version of the law, that argument wouldn't have really gone anywhere. And that was a big part of the case. So
it seems like such a strange thing for the government to hang their hat on. Like, this case presumably could have just gone away pretty easily. They're not really defending the original basis of the enactment that was challenged. But why did they want authority to be able to prosecute people under the statute with no knowledge requirement? It just seems like things could have been a lot less painful for them if they had given up on that one.
Well, so I think they had said, I don't think they had said that they wanted to, but they conceded that a prosecutor could.
I see.
And so when you're dealing with prosecutorial discretion, you're kind of lost there. And so I think the government kind of knew going in that they probably weren't going to win this case. It was just going to be a question of, can we survive this, or do we just have to rewrite the statute and try to, cleanse our new, potentially exactly worded statute of the discriminatory intent from 1877?
So I have an annoying procedural question.
Go for it.
Daniel.
The more annoying, the better. Let's hear it.
And I haven't seen the district court opinion, but it doesn't talk much about the relief that this institute got, but it does reference there was an injunction below. Do you know if the institute is suing like as associational standing for like its members who are, might be felons and want to vote, or it doesn't seem like it's a class action. Like there's never a class reference.
I don't think so. No, it might have been. So I didn't look into that. It might have been somewhat associational, but in the Fourth Circuit opinion, they do talk about how the institute, the Randolph Institute, its own efforts, its voting rights efforts were harder because of the chilling effect of the
right,
law.
because you go out and try to register voters. I don't know, if I can register. Okay.
Yeah, so they were saying that the institute itself had a concrete interest. So maybe it was a bit of both. I'm not quite sure.
All right. Now, of course, I'm asking that because my hobby horse these days is this universal injunction question, which the Supreme Court has basically shut down. Now, the district court ruled before the Casa case came out back in June, and the state probably doesn't care about the scope of the injunction. The state just wants to be done with this statute.
I think so.
So it didn't come out. I was just curious about that aspect. The wider question or maybe not a question I have for you, but just reflection, is the taint that comes from the purpose of the original legislature, right? That in a different context is a lot like, right, the intention of the framers of a constitution, whether it's the federal or state, or the framers of a statute, right? You've done a lot of work on Section 1983. So what was the intent of the Congress in 1871 or 1875 or whatever? And it's something that I think there's just no way to pin it down. And a lot of people are smarter than me have written about this, but there's a question of when something happens to a statute along the way, like it's enacted at a certain date by one legislature, and then later the legislature does something with it. Maybe it just adds like a word to make it clearer. Maybe it expands the number of crimes it applies to, like in this case. Maybe it just recodifies it. But what is that new? How do we take into account that new legislature or that new, constitutional convention? If we're talking about language from an old constitution, how does that change the intention of the embodied in the law, or change how we think about the law? I mean, there are all kinds of legal phrases out there that are borrowed where, it's kind of like Chesterton's fence. Like the original intention for that use of words is long forgotten. It's not maybe in this case. But long forgotten, and yet we use them. And so what do we even think about what that intent? Like the example I often give is the words we use in due process clauses today, and law of the land clauses and many other clauses come, maybe not originally, but we can at least take them back to Magna Carta in 1215. Yet we're not asking, like, what was the intention of the barons and King John in 1215? Because that's kind of absurd. And it's like 10 different documents back. But, like, how do we even think about that? How do we draw those lines? I mean, so this is like the mega question of constitutional interpretation. I would like you to answer it.
No, it really is. I mean, it's always a very tough question. I mean, I think one part of it in the Fourth Circuit actually kind of touches on this a little bit here, which is that, the 1971 Congress, when they were drafting this Constitution, they expressed no intent to change this law. And so I think, like, when a statute's retaining essentially, or at least substantively, the same language, and there's no expression of any intent to, interpret this a different way, then I think sort of maybe the presumption might be to afford the original meaning in 1877. I'm sure there are exceptions to that. And it always gets very difficult depending on the, whether you're dealing with a statute versus a constitutional provision and what type of constitutional provision. But I think that's kind of the gist here, which is that, I think there even had been a change to this law in 1899. I don't know that it really changed the law that much. Otherwise, it was pretty unbroken. And in 1971, with this new Constitution, the legislature expressed no intention whatsoever to change the substance or scope of this law.
I do think it's maybe an interesting difference between statutory law and constitutional law. I mean,
I agree, totally.
Yeah, like, if you're reenacting a statute, I kind of take that as the legislature saying we still mean it, and it being like the exact thing that statute was covering. When you abstract back to, like, the origins of constitutional law and the principles that predated that, I think you almost have to take it at a higher level of generality. Like, we may not mean that we want the government to be prohibited from doing the exact same things that the people who drafted Magna Carta wanted them to be prohibited from doing, but sort of the general principles and the higher level of abstraction are still things that we're carrying with us throughout time, and we do that by sort of echoing certain phrases or echoing certain ways of presenting arguments.
Right. No, I think that makes total sense. I agree with you there.
Great. Well, we figured that out. That's good to hear. So now we're going to move on to figuring out the Second Amendment. So we got a guy in Arizona. He's in a little bit of trouble. He gets a gun. He legally gets a gun.
Yeah.
And then he just wants to see the country. So what happened to him, Dylan?
And thereby hangs the tale. So speaking of abstraction and historical principles and levels of generality, let's dive back into Bruin. So I've got a case called United States versus Jackson. It's from the Fourth Circuit, just like the case that we just discussed. And it showcases the unique and depending on who you ask, pretty difficult to apply test for determining whether a law that burdens gun ownership is constitutional under the Second Amendment. So listeners to Short Circuit probably know this, but every episode has to be a perfectly contained thing of beauty. So I will be talking about the standard.
We got
in
news
Bruin.
Listeners every now and then. So you let them know.
Got to bring everyone up to speed. So the Supreme Court created the standard for questions like this with a 2022 case called New York State Rifle and Pistol Association versus Bruin. And the lower courts have been trying to figure out exactly how to apply that standard since it was announced in 2022. So turning to this case, United States versus Jackson, a man named Brandon Jackson was indicted for a felony in Arizona. It was a gun felony, but that doesn't actually matter to the case that we're going to be talking about. So he was out on bail for that state felony, and he traveled to Maryland with a handgun. So he traveled across state lines from Arizona to Maryland. Now, unfortunately for Jackson, that is a crime. Can't do that. 18 U.S.C. Section 1922N makes it illegal for someone under felony indictment, whether state or federal, to ship or transport in interstate or foreign commerce any firearm or ammunition.
So I got a quick question about that they didn't address. So that says in interstate commerce, which we all know means absolutely everything.
Right.
So was it illegal for him in the first place to, like, buy the gun and, like, drive it home inside of Arizona?
Now, I think a different part of 922N does prohibit people under felony indictment from purchasing a new gun, but if he had already owned the gun, he could keep it. That's a difference between somebody who's been convicted of a felony and somebody who's just indicted for a felony. So if he had already owned the handgun, it was fine for him to keep it in Arizona, but he could not buy a new handgun or take his handgun that he owned across state lines.
And it is that the state line's the obvious part, so that's what they're going after.
Yeah, that's what they got him on here. So Jackson was indicted on the federal charge. He was convicted. He, I think, pled guilty conditionally, subject to like still being able to bring this appeal. So he was convicted, but he still got to fight about this in the Fourth Circuit. And he argued that 922N, as applied to him, was unconstitutional under the Second Amendment, that it was unconstitutional to prohibit him from taking his gun from Arizona to Maryland. So before we dive into exactly what the Fourth Circuit did here, it's probably worthwhile to talk about the regime on dealing with gun restrictions that Bruen got rid of. So what courts used to do before Bruen was decided in 2022, they would first ask it was a two-part inquiry, and the first question was kind of originalist. It would be whether the challenged law regulates activity that fell within the scope of the right to keep and bear arms as originally understood. If yes, if the law burdened that right, then the courts would go on to ask whether the law burdened the core of the Second Amendment. This is where the circuits got into trouble with the Supreme Court, because they viewed the core of the Second Amendment as gun ownership for self-defense within the home, like a very protracted right. And so if a law burdened that core right, it would be subject to strict scrutiny, which is really hard for the government to prove. And if it burdened sort of a lesser Second Amendment right, it would be subject to intermediate scrutiny, which is a much more friendly standard to the government. So the Supreme Court in Bruen thought that this test underprotected Second Amendment rights. Wasn't good enough. And so it took away the two-part test that the courts had been using and replaced it with a new one. It says in Bruen that it's really a one-part test, but it's not. It's a two-part test. And so the new test has a similar first step, which is courts asking whether the plain text of the Second Amendment covers the conduct at issue. So here that would be whether the text of the Second Amendment protects your right to own a gun and transport it across states. And so if that's burdened, then we get to the second step of Bruen, which is quite different than what the circuits were doing before it was decided. And so now if the Second Amendment applies sort of at step one, then the government has to show that the challenge law is consistent with the nation's historical tradition of firearms regulation. And what that means has been tough for courts to understand, I think. But basically the idea is that the government has to dig up founding era laws or laws enacted shortly after the founding that regulated similar conduct for similar reasons. Now, how close is close enough is kind of the tough question in the Bruen analysis, but we'll get into that. So some people think that the Bruen test is a welcome change because it's a more robust protection for the right to keep and bear arms, and it has more of a original history and tradition spin to it than the test that it replaced. Other people say it's pretty much impossible to apply. So maybe we can settle the debate once and for all here. And so we'll do that by looking at the Fourth Circuit's case in Jackson. And so here, under the first prong of Bruen, whether the text of the Second Amendment protects the conduct at issue, the government tried to say that Jackson's decision to travel across state lines with a pistol doesn't fall within the plain text of the Second Amendment. And if that sounds crazy, it's because it is. I mean, that argument has really been laughed out of court, I think, in most of the cases that have challenged federal gun prohibitions since Bruen was decided.
I mean, that was Bruen itself. You were leaving the home of your pistol.
Right, exactly. And the only spin here is the across state lines part. And as you can predict, there weren't a lot of laws around at the founding that said you couldn't do that. And so the government offers a few really flimsy justifications to win on prong one. The lead one, their lead argument was that transporting a gun is not keeping or bearing a gun. And I mean, come on, guys. That's not very good. But they also have this other argument that the Fourth Circuit, I think, rightly kind of brushes aside, but it's worth talking about for a second. Because the government also argues that people indicted for felonies didn't have very many rights at the founding. And this seems to me to be a spin on the argument that the government's been making in some of these cases, that felons or people indicted for felonies aren't really part of the people for the Second Amendment purposes and the purposes of other parts of the Constitution, which is wrong. And I think courts have been correct in pointing it out as wrong. But it's a really troubling argument. I mean, you think of somebody indicted for a felony no longer being a part of the people for all of the rights that trigger when you're a part of the people. It's a really scary thing.
What other rights, like right to jury trial or
right.
defense attorney or whatever.
Right. And this argument, I think rightly, has been pretty much laughed out of court so far, but the government keeps trying to bring it in slightly different ways. And I think that courts should really be careful not to let any of those arguments slip through, because they're all dangerous and could have really bad knock-on consequences outside of the Second Amendment. So none of those arguments that the government made on Bruin Prong 1 passed the smell test. Obviously, owning a gun and personally traveling with it are actions presumptively protected by the Second Amendment. So things are easy so far. They get more complicated when we get to step 2 of Bruin, where the government again has to identify historical analogs in founding era or as close to founding era as possible regulations that support its ban here on indicted people transporting guns across state lines. So the big way for the government to succeed on this part of the Bruin test is to prove the how and the why. So they have to show that the earlier gun regulations, the historical tradition of gun regulations, operate similar to the challenge law, that's the how, and they do so for similar reasons, which is the why. And so we'll start by looking at 922N, the law that's challenged here. And the how and the why are pretty self-evident. The how is you can't transport a gun across state lines if you're indicted for a felony. That's just the law. And the why is really because Congress doesn't want guns in the hands of people who might use them to commit crimes. People who are indicted for felonies are probably more likely to commit crimes, so Congress wants to curtail their gun ownership. Okay.
Well, so really quick, so the why here, and maybe this isn't addressed in the case, maybe the government didn't raise this, but is it all indictments or is it just certain indictments?
It's felony indictments.
Sorry, all like violent felony indictments, just any felony indictment? Like, how broad did they want to go with this argument?
I don't think that came up in this case specifically, because the prior felony indictment here was on owning owning a gun that this guy was not allowed to own.
Yeah,
so,
like a short barrel
yeah,
or something like that, yeah.
But I'm pretty sure that there's no like distinction that I've seen the government making based on violent felony indictments versus nonviolent felony indictments. Now, I know on the felony conviction side of things that's an argument that has come up, but so far I don't think the government is conceding any ground.
But the statute itself, right, applies to all felonies. It's just felony indictments in this case, and usually it's a conviction.
Right, yeah. 922N is the indictment part.
Right.
Okay, so the government has to point to some kind of historical analog for 922N, and it offers 3. The Fourth Circuit buys 2 of them, so little spoiler for how the case ends, the law is upheld. But I'm going to start with the one that the court doesn't buy. And I think it's interesting because, to my mind, it's actually the best argument that the government has, but the Fourth Circuit disagrees. So the government's first justification is that people indicted for felonies at the founding could be imprisoned until their trial. Therefore, lesser restrictions on what people indicted for felonies are allowed to do are kind of included within the greater argument that they could just be thrown in prison. So here, if the government has the authority to imprison you until your trial if you've been indicted for a felony, it also has the authority to do something less, which is prevent you from carrying a gun across state lines. So the Fourth Circuit rejects this argument. It says the how is good enough, like just restrictions on who can own guns and when. The how's good. The why, it says, is not good enough. And I thought this was an interesting argument, because the Fourth Circuit says, look, it's a complicated mishmash of history, but when people were detained pre-trial at the founding, they weren't really doing that for the same reasons that we do it today. Today, pre-trial detention is largely about flight risk and harm to the public that might come if this person's out on the streets. And the Fourth Circuit says, actually, back at the founding, it wasn't really about harm to the public if the person's allowed to walk free. It was more about likelihood of guilt. So if it was really likely that you were guilty, and sometimes if you were suspected of a particularly severe crime, you wouldn't be given pretrial detention. But that analysis didn't really turn on whether people thought you were a flight risk or whether they thought you would go out and cause harm to other people. So 922N, in comparison, is all about future conduct. It's about preventing people who are under felony indictment from traveling across state lines with guns and committing crimes there. So the why just isn't good enough to the Fourth Circuit. Now, 2 other arguments were good enough, and the first one, as Anthony alluded to at the top, is the surety laws. These laws, which came into vogue a little bit after the founding, it was kind of mid-19th century when these laws
they kind of did a little eliding there, I thought.
They did, and we'll get to that.
Not a state law.
Yeah, right. And so these laws came into popularity in like the mid 19th century, and what happened was they allowed a magistrate to force people to post bond if they might be a danger to others. And sometimes this was a danger to others based on their likelihood of using a gun against others. And generally, it was much more broad than that. It was just if they thought that you were going to menace the public or be a danger to other people, they could force you to post a bond. And if you didn't, you could be imprisoned. So the court says that the how and the why here match up. Both are restricting gun ownership or forcing you. They're putting conditions on your gun ownership. And the surety laws, it was posting the bond if you wanted to continue to walk free and own your guns. And here it's you can still own guns that you previously owned, but you can't travel across state lines with them. So they're both restrictions on gun ownership. The how is fine. And they say the why also matches up because they're both prospective. The surety laws would stop you from walking out on the streets unless you posted a bond so that you wouldn't go menace the public or cause harm to anybody. And that's kind of the same animating logic behind 922N, which is that you can't go across state lines with your guns to hurt people. So the problem, and Anthony mentioned this too, is that in Bruin, the Supreme Court did not like the surety argument. And one thing that they really disliked was that they couldn't find any good evidence that these laws were ever enforced. So it actually raises a pretty interesting question about what is our history and tradition of gun regulation? Is it the laws on the books, or is it what people were actually doing? And for the Fourth Circuit, laws on the books was good enough. Laws on the books that postdated the founding by decades was good enough. And so it's interesting. But they have a backup argument, the Fourth Circuit. They say, if that's not good enough for you, we have another one. Because they like the government's final claim for why 922N is constitutional, which is that we have a historical tradition of prohibiting potentially violent or dangerous people from owning guns. Again, the Fourth Circuit finds that these laws use similar methods, like restricting your gun ownership to achieve similar goals, which is preventing violence. But I thought this was interesting too. The Fourth Circuit really glosses over how unsavory and by modern standards, how unconstitutional a lot of these disarming the dangerous laws were. So just to give a small snippet of what they were. These laws outright barred slaves from owning guns and Native Americans from owning guns because colonists feared rebellion from
and British loyalists, right?
Yeah, that's the other one. British loyalists and religious minorities. Now, the loyalists and the religious minorities who I think these laws were normally aimed at sort of white colonists who were maybe friendly to sovereign powers that were not the new United States. You could get around those bans by swearing an oath of loyalty to America. Now, if you were a slave or a Native American, you had no shot. You just couldn't own a gun. And I just think that it's a bit strange for courts to be relying on that particular tradition of firearms regulations to uphold modern laws, because what they do is they abstract as far as possible. It's not about slaves or Native Americans or British loyalists. It's about people who might be a danger to American political society. But I don't know if that elision really works for me, because if you go back and look at what all of these laws were doing, they would be blatantly unconstitutional today. And if we've repudiated sort of the basis for all of those laws, can they really still have a valid place in our historical tradition of firearms regulation? I don't know. I don't know if it'd be good enough for me, but it's good enough for the Fourth Circuit. 922N stands.
I sort of have two concerns there. I mean, one, we're just talking about someone who's indicted. And so, I mean, that seems a little sus at the very least. At least debatable whether, you can treat someone who's merely indicted as someone who's dangerous. I mean, I can at least see arguments both ways. The other one is, what was the closest historical analog to someone who was indicted, with the idea of someone being indicted being dangerous? Did they offer a close analog, or was it just like, back in the day, people who were deemed dangerous were prohibited from having guns, so potentially someone who's indicted is dangerous, and that's just like, that's it?
Yeah, it's interesting because, I mean, that really is it. They look to this tradition of disarming the dangerous, and they say, well, in Congress's estimation, by passing this law, they're saying they think indicted people are dangerous. And so that's good enough. But the one tradition specifically about the rights of indicted people, the one that the Fourth Circuit didn't go for, I think is the closer match here. But that's the one that, although two other circuits have said that the fact that indicted people could be incarcerated until their trial date was good enough to justify gun laws, that one wasn't good enough for the Fourth Circuit.
That is so interesting that they did those three justifications and they took the other two, because you're right. I think part of what's going on there is they're taking the first one about bail, which really is the best match, and sneaking it into third one about dangerous people, but they've already nixed that one. And I'm guessing the reason why they spent so much time on this bail argument and found it lacking is because these judges care about the bail right in the Eighth Amendment, that you can't have excessive bail. It is a right that has been given very short shrift and still is today in so many ways, especially in state courts where almost everyone gets pretrial detention sometimes, and instead of having this right to bail, to not having excessive bail, which should apply to just about everyone except the really dangerous criminals. And so they kind of beef it up a little bit. They use it as an attempt to beef it up, even though, this underlying case is about just this firearms prosecution. I also just found that the bail stuff really interesting, because they talk about these common law model states, which I'm guessing is the Old English model, where there was a little bit more leeway to lock people up. And then some states had this, quote, dissenter model, which I thought they meant like dissenting Protestants or something. But no, actually, it's just like it was the minority rule or something, where it was easier to get bail. And then it didn't have, in the end, it didn't seem to have much to do with the analysis of the case, but it was just some interesting history.
Yeah, I agree. And, I say that the pretrial detention example might be the best one for the government to hang its hat on here, but there are problems with that argument. I mean, the first one being, even if you take it at the most basic level, this is probably ignoring some nuance from all the different approaches that states took, but imagine that you could be denied bail until your trial for felonies. Now, I mean, that term felony at the founding carried a much more narrow meaning. It covered a much smaller class of crimes than the class of crimes that we have now. And so even giving the government the ability to strip gun rights from people accused of felonies, today, it's a much wider class of suspected criminal conduct that could lead to these consequences than it would have been at the founding, which that's a problem. And I'm just very concerned about this final argument that the Fourth Circuit found persuasive, which is the dangerousness one. I mean, just the idea that Congress or any other legislative body can brand a certain group of people dangerous and then strip fundamental rights from them, Second Amendment or not, is very frightening to me, despite what we may have done to Native Americans and slaves back in the day. I think that probably makes it worse, not better.
And if we look at the actual facts of what happened to this guy, Mr. Jackson, he actually, it looks like in state court, pled to he pled to a misdemeanor.
He did.
And he was never found guilty of a felony. This is the only felony. And it's a felony for having a felony, in a sense. So anyway, he's sentenced to time served. So I guess he's today, as long as he hasn't done anything else, he's doing fine, even though his case is over. Or is it over? I guess we'll see. We'll follow up on that. But for now, thank you guys both for this history tale. And for everyone else, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.